Canadian court declares two major Nigerian parties as terrorist organizations. The Federal Court of Appeal in Ottawa, Canada, has determined and declared that two significant Nigerian political parties, namely the ruling All Progressive Congress, APC, and the People's Democratic Party, PDP, are classified as terrorist organizations accountable for widespread acts of terrorism and involvement in subversive activities against democratic processes. This final ruling was determined after a 7-year-long legal tussle between a former Nigerian politician, whom was a member of both the PDP and APC parties respectively, versus the Canadian Ministry of Public Safety and Emergency Preparedness. Mr. Douglas, a periodic member of PDP and APC, but whom subsequently moved to Canada and applied for inland refugee status, had his application flagged and denied by Canadian immigration authorities, and after investigations about his antecedents, the immigration officers concluded his inadmissibility in Canada, and this was ruled by the Immigration Appeal Division, IAD, on March 25, 2024. However, Mr. Douglas Egarevba filed an appeal at the Canadian Federal Court seeking judicial redress over the ruling of IAD, denying him ineligible to reside in Canada. In his appeal, Mr. Egarevba argued that though he was indeed a member of the aforementioned duo, he, however, did not personally participate in illegal or terrorism activities as deemed by Canadian court and justice system, further asserting that the democratic processes in Nigeria was far from comparable in view of Canadian standards, as the acts of violence was a recognized norm in the Nigeria electoral system. Notwithstanding, the Federal Court of Appeal, after thorough assessment, upheld the position and ruling of the Immigration Appeal Division that Mr. Douglas Egarevba was inadmissible and ineligible for the inland refugee status, owing to his membership to organizations deemed by Canadian state as perpetrators of acts of terrorism. Given this context, I find that the IAD's conclusion on the applicant's membership with the PDP for the purposes of a determination under 34(1)(f) was reasonable. I also note the IAD's uncontested finding of fact that the applicant had testified being aware of ballot box snatching and political violence in Rivers State, but not in Edo State where he was located. However, the decision referenced objective evidence that reported deaths and incidents of violent intimidation in Edo State during the elections. The IAD stated that while knowledge was not a required element in assessing admissibility as a member of the PDP, the IAD found the applicant most likely downplayed his knowledge and the seriousness of political violence committed by the parties in which he was involved. I see no reason to intervene with the IAD's conclusion on the applicant's membership with the PDP. The judgment read partly. Family Writers Press International.